Welcome, everyone, to the March 2025 Morning Blend. This is our first morning blend of the year, and it coincides with 5 years ago when we launched this program, not necessarily the same month, but it's interesting that we launched it during a time of tremendous change and uncertainty, and here we are. I think every time Lori and I plan for this program, and we think, what are we going to talk about this time? And there's never a worry that there are going to be topics to cover. And certainly that's no different for today. I'm Allison DeFlorio. I'm one of your co-hosts for today, and thrilled to have back once again my partner in crime from Fox Rothschild, Lori Armstrong. Hi, Lori.
Hi, how are you?
Good.
Just a technical point for those of you who don't know me. If you're trying to look me up and you don't find Lori Armstrong, I go fully by Lori Armstrong Halber. That's a lot of words, but I'm very happy to be here. We have a lot to talk about. And I do want to sort of make this disclaimer in the beginning. We are not trying to politicize our discussion, but the fact of the matter is there is an impact and there are constitutional considerations and other considerations that we're going to be talking about. And our goal really is to help you understand how these changes are going to impact you or give you some suggestions as to how to navigate them. But I do want to recognize that these are sensitive topics for folks. And we are doing our best to sort of be objective. But frankly, as a lawyer, there are a lot of things that are going on that are troubling in terms of what I think people should have learned in basic civics class and the judiciary and how the three branches work together. So
Great. Just as a reminder for everyone, we are recording this session, so we're happy to send the link out post-session. Please share it with individuals that you think would find value in the conversation today. Your phones are on mute, or your computers are on mute, but your questions are important to us, so please feel free to use the chat feature, and we will do our best to address as many of them as we can. Our contact information is on the last slide, which will also go out with the presentation, and you can certainly feel free to reach out to either one of us. And with that, we're going to go ahead and do our traditional introduction. So for those of you that have tuned into the Morning Blend in the past, you know this, but for those of you that are joining us for the first time, again, I'm Allison. I'm the co-founder and managing partner of Exude Human Capital. Exude is a full-service human capital firm headquartered in Philadelphia, and we focus on three areas. We focus on human resources, inclusion and equity, and leadership development. And our approach to the work that we do is that you have to really think about all three of those lenses in order to have an effective, inclusive work environment. You can have the sound, compliant HR processes and policies, and they can be done through the lens of inclusion and equity. And if your leaders are not effectively trained and developed to administer those, that would have an impact. I hope to share with you today some of the things that we're learning from our employers that we've been working with the over 200 clients that we support as we've been navigating through these changes since January of 2025. And Lori?
well, good morning again. I have been practicing in this space of workplace law, traditional labor, and employment for almost 30 years now. And I've represented everything from small mom and pop shops to large Fortune 500 companies. And I've done everything from federal jury trials and discrimination cases and wage and hour claims to traditional labor. And really, my favorite thing to do at this point in my career are sort of proactive conversations with clients, whether that be training or counseling, advice, that sort of thing. And so it's always a pleasure to be here with you, Allison, and your team, and talk to these folks about what's going on in the world. I should say that Fox is a full service firm. We have offices all throughout the Philadelphia area, in the suburbs as well as offices all across the country. And I have partners that do everything from domestic relations and family law up to corporate M&A. So we're available if you need help on a broader stage.
Great, thank you. So into our program for today, our piping hot doesn't need much of an introduction. There have been a few executive orders and other actions from the administration. Lori's going to give us some updates there. And then for our Daily Brew, we're going to talk about navigating inclusion in this world of uncertainty. We'll talk about some of the recent EEOC guidance and then inclusive practices, transparency, and employee well-being. We'll leave you with some tips and things that you can take back to your organizations that you can focus on. And just know that as these things are emerging, there will continue to be guidance that will come out after this session. We'll do our best to keep people posted on changes. So with that, I'm going to turn it over to Lori for our piping hot.
Oh my gosh, there's like so much.
I know.
So the first thing I want to talk about, actually, before I even get to appointments and terminations, are some kind of principles that I think you need to understand, because it kind of explains why there's so many legal challenges and so much uncertainty. So for those of you who never had civics class or don't remember civics class or didn't watch Schoolhouse Rock on Saturday mornings, the way our government is supposed to work is, the system of checks and balances. So Congress, that's the Senate and the House of Representatives, is actually the legislative body. They're the ones that make the law. The executive branch can veto a law, but then that veto can be overridden if there's a supermajority in the Congress. But I just want you to understand kind of what everybody's role is. The executive branch, who is the president, has the right to set policy, has pretty broad rights when it comes to sovereignty and immigration issues, but doesn't actually have the right, other than through veto power, to change laws. That's not the way it's supposed to work. And the judiciary is, they sort of review the actions of the other two branches and really are there to, they wouldn't say this, but enforce the Constitution. So if Congress passes a law that is contrary to the Constitution, you might see a case come up and then the Supreme Court would overrule that statute. Or in this case, we're seeing challenges to different things that President Trump is doing. And so I'm giving you that background because it really impacts what's going on here. So for example, 20 days into his presidency, he fired 2 Democratic members of the EEOC before the end of the normal terms. And he also fired the NLRB, it should say Democratic board member, Gwynne Wilcox. And that may seem like, well, it's the president's prerogative, he should be able to do whatever he wants. But in fact, Congress set up, as they passed statutes in this space, so for example, the National Labor Relations Act or Title VII, Congress also created federal agencies to interpret and enforce those acts. And in the actual language of the statute, it explains what the role of those agencies are. So we're seeing a conflict between what the president believes is his prerogative and what many people believe is an overreach because these positions are established by Congress. The day after he fired the 2 Democratic members, by the way, all of these boards are set up by Congress to be somewhat balanced, to have, we've talked about the National Labor Relations Board, 3 Democrats, 2 Republicans, and a Democratic administration. They're supposed to roll off so that if there's a Republican administration, it's 3 and 2, so that no one party, while there may be a majority, it's not, 5-0, okay? So on January 28th, he appointed an EEOC commissioner who was already on the EEOC commission, Andrea Lewis, as the acting chair of the commission. But she has been very vocally critic of DEI programs, among other things. And we'll talk a little bit more about her later. So between firing 2 of the Democratic members and elevating her to that position, he's really changed the complexion of the EEOC. And that's a lot of what we'll be talking about later. With respect to member Wilcox on the board, she challenged her termination, and the U.S. District Judge has reinstated her. Trump administration has appealed, and it's sitting in the district at the D.C. Circuit right now. These are really, like, as I kind of go through them, you're like, it's personnel, but these are actually really big issues. If you go to law school, the first case they teach you is Marbury versus Madison, and it's really about the court deciding what its appropriate jurisdiction is. Marbury being the founding father in that discussion, Madison being a different person, one being the justice and the other being a founding father. And so this is really a constitutional crisis in a way, because it's really about how the courts rule is going to really dictate how those checks and balances continue to work. On March 10th, and we already talked about this in the fall, you may remember, but the Senate confirmed Lori Chavez DeRemer to lead the DOL. And this was really a surprise pick. You may recall when we talked about it before, that President Trump had it as early as November, right after the election, he was talking about that he picked her. But some people are skeptics because, particularly in the employer community, you would think, given other statements by President Trump and his administration, pro-employer statements, that they wouldn't pick someone like her because she positions or has traditionally positioned herself as pro-union and supportive of labor rights. So that's sort of interesting. We don't have a lot going on in the DOL right now. We haven't seen guidance. We haven't, had firings or anything as we have with the EEOC and the NLRB. So I don't have a lot to talk about on the DOL other than as it pertains to immigration. So executive orders, it's sort of interesting. This is an observation. The Republican Party had traditionally been very critical of President Obama for his use of executive orders. And yet I don't remember ever there being this many executive orders in the first, 2 months of an administration. So I'm only attending to some of them. There are more that I haven't included here, but these are the ones I think are relevant. Interestingly, if you recall the FTC's non-compete rule, we ruled as dead in September. This is also a little interesting because it doesn't seem consistent with what you would expect. But on February 26th, the FTC committed to targeting non-competes. It says it intends to continue scrutinizing non-compete agreements and more. So that would include non-solicitation and other restrictive covenants. And the commissioner, appointed by President Trump, has unveiled plans for a joint labor task force to identify and prosecute labor market practices the agency deems to be deceptive, unfair, and anti-competitive and harmful to workers. So I don't have much more on what that really means right now, but it's a little odd given that a Republican appointed majority ruled that the FTC rule was unconstitutional. I'm not going to go through this again, but you may remember there was a Supreme Court decision last summer where the Supreme Court basically said that agencies aren't entitled to the deference that we had been giving them. Instead, it's up to the courts to decide questions of interpretation and constitutionality, which has led to, in New Jersey, the district court might say one thing, and in Philadelphia, the district court might say something completely different. And now we're at conflict, and we haven't seen this shake out yet, but it may lead to a lot more cases going to the Supreme Court. So anyway, stay tuned on non-competes. Immigration, super hot. Day one, 10 immigration executive orders, including declaring a national emergency at the US-Mexico border and an attempt to end automatic birthright citizenship. That second order has been enjoined. There's been an aggressive immigration stance by this administration. It says that the Department of Justice will use, quote, all available criminal statutes to combat the flood of illegal immigration and to support the DHS's Department of Homeland Security, their immigration removal initiatives. There is a plan that is set to take effect on April 11th, where they're going to expand this notion of alien registration. So there would be a registry. 3.2 million non-citizens would have to register with the government, provide biometric data, carry proof of registration. It's not entirely clear how that's going to affect folks. It's not entirely clear whether or not employers may have a role in that vis-a-vis like Form I-9. But the thing that you do need to be aware of is there has been a marked increase, you've seen it on the news, in enforcement activities, including workplace raids. And my immigration colleagues, as well as colleagues across the country in L&E and immigration, have said that they are, how do I put this? They come in and they do what they want. Like in the past, there has been certain orders, certain rules. They have to provide certain warrants. And basically we're seeing ICE come in and if you have non-immigrant workers or even green card holders in your workplace and you have any concern about this, I will put you in touch with one of my colleagues because we're trying to give advice as how to navigate this. But most folks are saying we don't consent to a search, and ICE is saying we don't care, and they're just doing whatever they want anyway. And it's very unsettling. So the immigration area, I mean, it was one of the things that the president ran on. It's not completely surprising, but it is another area where there is significant concern as to the constitutionality of the actions of a federal agency. So DEI and equal opportunity compliance. I know this is really a big one, and it's probably where we'll spend most of our rest of our morning talking. The EO that the president signed on January 20th, again, first day in office, is entitled Defending Women from Gender Ideology, Extremism, and Restoring Biological Truth to the Federal Government. It requires the federal government to recognize only two biological sexes. It actually says as determined at conception. Just sort of a fun fact, we're all female at conception, but whatever. Really what it matters for all of us is that the term gender is now being taken out of all official documents. They're putting in the word sex. They will only issue biological sex assigned at birth government-related documents. But what's really, again, putting us in line for this constitutional showdown, hence my civics lesson in the beginning, is that the president has ordered that the concept of gender identity should be removed from all federal anti-discrimination laws. And that seems to run counter to that Bostock ruling that came down in, I think it was 2019. Bostock was the Supreme Court case. It was authored actually by a Republican appointed justice, surprisingly. And in that case, it was held that sex in Title VII means both, well, means all three: biological sex, but it also means sexual orientation and gender identity, that it is comprehensive. That this is likely to end up in front of the Supreme Court. We'll have to see. We've seen that this Supreme Court has no problem overruling decades of legal precedents. So this is kind of a stay tuned, folks, on that issue.
Lori, as far as language in handbooks around gender identity at this point, what's your guidance?
I think you do what you feel is right for your organization, because there are a couple of other constitutional issues I didn't even get into. So when the government starts telling you how to write your handbook, there is arguably a First Amendment issue there. They are telling you not to be as inclusive as you're allowed to be. And again, Civics 101, the government's role is to set basically minimum standards, so the government can tell you, for example, race-based discrimination is illegal, and using racial epithets in your handbook is a violation of law. But they can't restrict rights of, that's not restricting a protected right. This is so confusing, I know. But they can't tell you that you can't use language that's not otherwise unlawful. So to do that, they would essentially have to say that gender identity is a crime or is a violation of law. Same thing with sexual orientation. So I don't know. And here's the other thing. All of this is in flux. We don't know how this is going to, we don't know what the court's going to say. I don't know that it makes administrative sense to go and redo all your handbooks and then have to redo them again 6 months or a year from now. We're going to talk a lot more about how to navigate sort of the language issue, but I don't think I would go around changing handbooks just yet. Plus, the city of Philadelphia still has an ordinance that protects against discrimination on the basis of sexual orientation and gender identity, as does the state of New Jersey, as does other state and local ordinances. So even if the federal government is trying not to provide protection on those bases, there are other states and local governments that are.
Great.
This is actually, I think, what a lot of people are worried about. It says, and you're not a federal, none of you, I don't think, are with federal agencies. So we read it and we tend to think it means us, but the Attorney General is really looking to enforce these initiatives at the federal level with respect to federal agencies, to the extent all those people haven't been fired yet. So all federal agencies are going to reverse any of those policies, including things like gender identity based access to single sex spaces. Those reversals and other Biden era actions, including the 2024 EEOC workplace harassment guidance that expanded protection for pregnant LGBTQ plus workers that we talked about over the summer, this administration is wiping all of that out. But again, that doesn't mean that, for example, in the city of Philadelphia, you still have a legal obligation to provide protections on the basis of gender identity. And it doesn't mean that you can't provide those gender protections outside of the city of Philadelphia. The legal challenges are going to come up that somebody is going to file a suit testing this, saying, well, I'm a woman and I don't want a man in my bathroom, and therefore I'm discriminated against in some way. And the court somewhere along the line is going to have to flesh this out. But if you have unisex bathrooms, and I know a lot of my clients, particularly in Philadelphia and Pennsylvania, have just decided they're going to have unisex bathrooms, it's a lot more difficult for the government to intrude on those sorts of decisions.
So you really have to pay attention to your state and local jurisdiction.
Yep. Now, there are orders that the EEOC has said that there's not a lot coming on from the DOL, but similarly, any agency that is charged with enforcement of these issues, they are really, so in the past, I might have said to you, the EEOC on their hot list or their initiatives are, they're looking for example, discrimination against folks on the basis of gender identity, or discrimination on the basis of religion, or the discrimination post 9/11. Their initiative was to make sure that we weren't having discrimination on the basis of national origin, which meant that if those kinds of charges came in, they got a lot more attention, because that was part of the initiative that the EEOC was, was focusing on. Well, now you're going to see kind of, for lack of a better word, because I think you'll understand what I mean, but quote, reverse racism claims, or Christian religious discrimination claims, and or people who claim that they're being discriminated against because they have to accommodate or deal with or accept or whatever folks on the basis of gender identity or sexual orientation. And the EEOC is going to flag those, as we're going to get to in a minute. The fact of the matter is, the law has not changed in this regard. And so some of what we're going to talk about is going to remain the same for you. Mm-hmm. Let's talk just a few more about some of these EO orders and then get into kind of the meat of it. Mm-hmm. So on January 21st, we got the we'll call it the anti-DEI order. It dismantles affirmative action standards for federal contractors. So to be clear, it eradicated the LBJ. So how old is that? I mean, 50 plus years old, 60 plus years old, had set forth affirmative action standards for federal contractors. Those are somewhat goal setting. The OFCCP would take in your affirmative action plans and review to look for discriminatory hiring practices and things like that. Well, not only has this administration said, well, we're not doing that, but they've also told the OFCCP that they can't allow or encourage DEI programs. And I will tell you, as a lawyer, putting aside any personal feelings I have about this, I think this is an overstep, because it has always been the law that you can't make the decisions based on protected classes. And when I have done training for the past 30 years, I have always said Title VII doesn't only apply to non-white guys over 40, right? It means that I can't go, I don't want that person because he's a man, or I don't want that person because she's a woman. It's always meant that. And this notion that DEI programs are somehow inherently discriminatory is actually kind of backwards, because it's interesting. So, side note, I was in Thailand a couple of weeks ago with my brother. My brother just turned 60. We disagree vehemently on politics and religion, but we are very, very close. And he was telling me, he's just retired. He was telling me, well, at my company, he didn't call them DEI hires, but he was like, unqualified people were hired, over qualified white men all the time. And I just was like, really? Because I'm fairly certain those qualified white men could have sued and should have, if that were the case. And the company would have had to come up with legitimate, non-discriminatory reason, just like they would the other way around. And if they don't have one, it's a violation of the law. That's always been the law. And the reason I say this notion of barring DEI programs is, number one, problematic because the government is restricting employers' First Amendment rights, but it's also problematic because it suggests that inherently anybody who falls into a quote DEI category is not qualified. And that's just
Not the case.
not the case. Allison, I'm not saying it. You know what I think. Anyway, going on, it directs federal agencies to combat illegal corporate DEI programs in the private sector. Look, it's always been illegal to have quota systems or to say, we're only considering a woman for this job, or that's just the other side of the coin. We're only considering a man for this job. Always been unlawful. But this is really creating a fear that I think is unfortunate because we're impacting people. And I mean, I think this is bluntly, and maybe this is political, but bluntly, I think it's what they want is to discourage people from hiring people of color, women, people over 40, because the way this is phrased, it suggests that you're going to have to like super double, quadruple explain why, justify why that person has been hired instead of, a non-person of color, non-woman, et cetera. Anyway.
And we are going to talk a little bit later about, the importance. It's always been important to track your decisions and your rationales for decisions and promotions, all of those kinds of things. But now more than ever, it's going to be important for you to have good structures in place so that you can defend why you made certain decisions about hiring, firing, promoting, pay, all of those kinds of things.
So on February 3rd, a group of chief diversity officers, professors, a restaurant group, a whole bunch of people joined together and filed a complaint in Maryland challenging this order as unconstitutional. I've already given you why I think it's problematic. In middle of February, Democratic state attorneys issued joint guidance reaffirming their position that DEI remains legal and important to the modern workplace. On February 21st, a federal judge apparently agreed that that the plaintiffs in the case challenging the anti-DEI order have a reasonably likelihood of success. That's how you get an injunction. You can't just go in and say, I think this is wrong, let us sort it out. You have to establish that you have a reasonably likely, good chance of success in order for the court to issue an injunction and say, well, we're going to stay this while the legal proceedings are going forward. It doesn't guarantee that the plaintiffs are going to win, but it does send a message that there are some problems with this DEI order. Other things, I mentioned this already. On January 21st, he revoked LBJ's order that required federal contractors to engage in race and gender affirmative action, and told the OFCCP to immediately cease enforcing it. And on January 24th, the acting Secretary of Labor ordered all FCCP employees to cease and desist any and all investigative and enforcement activity under the revoked 1965 order. Well, what does that mean? That means if you were being investigated for, racially discriminatory hiring or other, hiring that would be in violation of Title VII, those investigations have been put aside for the time being. So,
Woo.
Yep, there's a lot.
What a windfall that has been. So what does this all mean for all of you? And that's going to be the focus for the remainder of our conversation today, really is navigating inclusion in uncertain times. I am going to have Lori talk about the EEOC guidance that just came out a couple of days ago, like less than a week ago. And then we're going to talk about what are inclusive practices, why transparency matters, and importantly, employee well-being during these uncertain times. So, Lori, let's kick it off by you kind of talking about this guidance that was issued. And I understand there's going to be more guidance issued in April, but what are your thoughts? Why don't you share with everybody what this is, and if you haven't seen it?
So the acting chair, as I mentioned before, has long been a vocal critic of a lot of the Biden policies, um, and issued a statement going along with the guidance. This was the statement that, consistent with the president's executive orders and priorities, my priorities will include rooting out unlawful DEI motivated race and sex discrimination. Read that to mean what we would have called reverse, that we're going to look for cases of quote reverse discrimination, where essentially men are not getting jobs that allegedly they should have gotten because they were more qualified, and underqualified, air quotes, people of color or women are being given those employment opportunities instead. That's what that means. To be clear, I'm not politicizing that. That is what that means.
And that also, my understanding is, with the additional documents that were included in this guidance, includes internship programs, any sort of mentorship programs, anything like that, any
Yep.
development programs.
Any sort of opportunity that impacts the workplace on any level. Protecting American workers from anti-American national origin discrimination. Now, so here's part of the challenge with this is that, and this goes hand in hand with the immigration policy of the administration. The law has always prohibited discrimination on the basis of national origin. Interestingly, what I have not seen addressed, so the Immigration Reform and Control Act, I've said this before, was issued during the Reagan administration. He's the one that signed it. That's the law that created Form I-9. But just so you know, by way of background, that law legalized the majority of undocumented aliens in the country at that time. It was considered to be a reset. And then it established basically two balancing obligations. One is that employers must confirm an employee's identity and eligibility to work in the United States, but also prohibits employers under IRCA, not under Title VII, under that separate statute, also prohibits employers from discriminating against people on the basis of their national origin or citizenship, unless it's a federal job, and then it's in some cases you're allowed to require U.S. citizenship. And so this is again one of those protecting, I don't know how else to say it, white Americans, I guess, from being disfavored in favor of people from a different country. I mean, that's what that means. So it assumes that white Americans are being displaced by foreign workers. I'm not here to say whether that's true or not. I just want you to understand that that's what the language is. Defending the biological and binary reality of sex and related rights, including women's rights to single sex spaces at work. And some of you may understandably have feelings about, for example, bathroom use, bathroom stall, and all of that. And I can understand sort of quote both sides of that argument. But this is broader. I don't know if you're reading it, but single sex spaces at work is a little bit like separate but equal. And one of the concerns is that that's what we're moving on to. Protecting workers from religious bias and harassment, including anti-Semitism. I mean, there has been a spike in anti-Semitism. I know a lot of my clients are dealing with tensions at work for people who support Palestinians versus Israeli. That conflict is very complicated. So I there may be people who think, well, that's not a bad idea. The only thing I will say is that the administration is also favoring, and this to me is constitutionally problematic, just so we're clear, favoring task force fellowships, looking for protections for Christian organizations only. We have the separation of church and state. The problem with that is, if we're going to do that, then it has to be for all religions. So this again has some underlying subtext that may lead us to some messy situations, because the law says, the one by Congress, you can't discriminate on the basis of religion. That means you can't favor any particular religion over any other religion either. And remedying other areas of recent under enforcement. So where they believe the EEOC has been focused on things that she doesn't think are the right things to focus on, they're going to look in other areas. Note that she dissented with respect to the EEOC workplace harassment guidance that focused on LGBTQ workers and the finalized rules relating to the Pregnant Workers Fairness Act. We spent a fair amount of time talking about those obligations. They were intended to encourage inclusivity in the workplace, the premise being that we shouldn't be focusing on non-job related issues at work. We're supposed to be looking at, qualifications, performance of duties, and that sort of thing. So this is a pretty significant shift. The guidance itself, and then Alice and I will thankfully shut up. But the guidance itself is sort of interesting because all it really does is restate the law. It talks a lot about, the law says that you can't discriminate on the basis of race, color, gender, national origin, whatever. And that is what the law says. It's what the law has always said. So there really isn't a change. You could never make hiring decisions, if you had two qualified applicants and, it was just as illegal to say, well, I'm going to pick the woman and not the man as it was, I'm going to pick the man and not the woman, flip a coin. But ordinarily, and I know, Allison, you're going to start talking about this in a moment, there are business reasons why people make those decisions. I think there is an argument for diversity bringing perspective to the workplace. I do a lot of training in this area. Not every over 40-year-old white woman like me thinks the same. And I don't have the same experience and the same things to offer that, a white guy under 40 might, or a person of color over or under 40 might, or, there is space for inclusion, and it is notwithstanding the subtext of some of these orders and some of these policy statements, it is not unlawful to continue to hire people who are women, Jewish, Christian, Catholic, Buddhist, whatever, disabled, people of color. Like those protections remain in place, and the law has actually not changed. It's the focus and the way it's going to be used that's going to be different.
And I think that that's, a perfect segue into, so what do you do now? And start with that overarching, what does your business need? There's a business case for inclusion in the workplace. There's a business case for having multiple perspectives reflected in product development, in customer service, to reflect those that you serve, your clients, your customers, your guests, however you refer to them. So what our guidance has been, and what we're seeing our employers do, I would say, honestly, I can say 100% of the employers we work with want to have an inclusive workplace. They want the people that they have hired to be able to come and feel safe, contributing ideas, suggestions to their work, and feeling that they belong. So you should take a look at your business processes to ensure that you're continuing to create opportunities for those that you have hired into your organization to thrive, to be able to contribute, to be able to bring their best to the table, and allow for their voice to be heard. There is an opportunity to review your policies and practices to ensure that there are not policies that are unintentionally discriminatory, or practices that are unintentionally discriminatory. Again, many of you are likely abiding by the laws as the laws sit today, and that you are, on the heels of what Lori just said, making the best hiring decision based on the candidates that are put forward to you on their skill and experience, regardless of other protected characteristics. So, but taking a pass at looking at your policies, there's a best practice to have kind of a cross-departmental work group take a look at those policies and practices and think about the entire talent life cycle. So think about recruitment and selection as a starting point. Go through your processes and policies through to onboard and hiring. think about pay and benefits. And, we had mentioned back a little bit, this is your time to ensure that you have good practices and structures in place to document the decisions that you're making when it comes to any sort of employment decision. I think quite a bit about compensation decisions. We've been working with a lot of employers in this space to help them make sure that they have a structure that is sound, a framework that is for decisions around pay that is based on well-validated data, and that there is criteria in place as to what constitutes somebody making what they make based on their experience, their skills, whatever they're defining, so that if you are asked to certify your practices or defend your practices, that you have well documented processes and practices in place. And this goes all the way through to training and development. Take a look at your programs, take a look at the content that you may be bringing in from outside organizations to ensure that there's not unintentional discriminatory or preferential treatment suggestions in those practices. And to offboarding, when you're making decisions around termination, what are you making those decisions based on? Again, many of you likely have these things in place, and if you don't, it's a good time for you to step back and either do that internally or reach out to firms like Lori or ours to give you guidance on how to go about doing that. Transparency is going to continue to be a big driver, and that's transparency in how you make decisions. There's a positive outcome to making sure your policies and your practices are sound and well documented is that you can be very transparent with your employees about why you make certain decisions, and that we see that again in the work that we do. Organizations that include a broad cross-section of representation from an organization and giving feedback around policies, giving input to practices, and then making sure that they understand why the decisions were made. That transparency means that people are informed of why you're doing what you're doing, not just what you're doing. And lastly, I want to talk about, these uncertain times, I'm sure you're seeing it in your organizations, are creating a lot of stress for employees and employee well-being. Many of you may have employee well-being programs in place. Many of your health benefit products embed them. Now is the time to make sure that you are communicating those effectively, that during check-ins with employees, you are checking in on the individual in addition to the work that they're doing, because there's this type of environment that we're in with the constant change. You hear that employees are feeling a lot of change fatigue, can impact their well-being, which can impact their performance, which can impact engagement and turnover and retention and all of the things that have true dollar value to your organization. So it's important that you have good processes in place to check in on them, and that you keep them informed of programs that are available. Lori, do you want to add anything?
No, I keep coming back to, I think what you and I have always said in terms of managing your workplace, if you're doing those things, even under this seeming shift at the federal level, you'll be able to defend anything that's challenged, right? Having inclusive practices isn't a per se violation. And I'm reiterating, and I want to be repeating myself, that we have always said that you shouldn't be making decisions on the basis of these protected classes. And that really hasn't changed. And so all of the things that Allison is talking about, I think, keep your workforce engaged. And I do think there are a lot of people who are very, for lack of a better word, stressed doesn't begin. About half the population feels like the world is coming to an end. And maybe the other half of that, maybe 30% thinks everything is great, and maybe 20% really don't care. But you have a pretty substantial number of folks who are barely getting through the day these days. So
Mhm. So some considerations, and some of this is what we just spoke about, but review that talent cycle, policies, practices, training materials, check for language. And Lori, I invite you to chime in here, but check for the language so that it is non-discriminatory or preferential. Many of you may have employee business groups, employee resource groups, however you frame them. Traditionally, those have always been open to all people. They tend to be focused on specific groups to provide resources and support. You should have them open to all people if they are not open to all people, so that they are not discriminatory. So if you have a women's group or Latino group, that they should be open to everyone.
I really hesitate to say this because I don't want to discourage those groups, but I think it's pretty clear that the current administration finds those to be problematic.
Mhm.
And I'm going to be flat out snarky here. I don't know that they would care so much about like an old gentleman's club. They might think those are just fine, but um, I don't want you to think that just because Allison and I are telling you like, make them open to all, that you're not going to assume some risk that this administration may, take issue with them. That said, I think they're defensible, and I wouldn't. Some of these decisions you're going to have to make are going to have to be business decisions, knowing that keeping an employee resource group may invite scrutiny by the EEOC under the current pronouncements.
Mhm. Um, and think about if you are asked to certify your practices for as a federal contractor for receiving contracts or grants, that those might be things that would be looked into. And again, as long as you have it documented that what your practices are for attendance at those groups. Leadership development and inclusion training, we still have clients that are forging ahead with creating inclusive workspaces and offering opportunities to all within an organization for around leadership development and inclusion. I will just make this comment. I think facilitation of those sessions matters because in inclusion training, and we see this in the work that we do, can be highly emotional. There can be conversations that come up where people share opposing viewpoints. And in those trainings, people have to have voices. You have to be able to listen, and you have to be able to hear, not necessarily agree with, but hear many different sides of perspective. So I think just be mindful that when you do facilitation of these sessions yourselves, or you do bring in people to facilitate, that they are trained to handle those types of conversations, because it may leave attendees feeling as though they were discriminated against. And that was something that came out in the guidance. At least that's how I interpret it, Lori. I don't
Yep.
know if you want to speak to that.
No, and you and I have had this conversation, and I think some of this is a backlash. This is Lori Armstrong Halber speaking based on my experience. I'm not speaking on behalf of Fox or as, whatever. But I believe, based on my experiences and having sat through some of those trainings, not the ones that I provided, that the the message didn't create space for, by way of example, white men under 40, right?
Agreed.
There was a feeling that Title VII protects, everybody said this in the beginning, other than white men under 40, because you all don't need protection. And that is marginalizing. And I think that is what has led us to this space. That is not what the message should have been, in my opinion. Much like I think when we were talking about, in the women's right movement, when we said, okay, it's okay for women to work in the workplace and do traditionally male jobs, we didn't do the reciprocal. We didn't say, and it's also okay for men to take on traditional female
Right.
responsibilities. That has changed a little bit more recently, but without creating space for everyone, which is really the definition of inclusion, somebody feels marginalized, and it leads to these sorts of challenges like we're facing today.
Mm-hmm. Mm-hmm. And I think we've said this on every program we've ever delivered in 5 years, making sure your managers are up to speed and understanding the employment laws as they connect to your policies, know what their responsibilities are. They need to have that basic employment law connecting the dots to policy training. now more than ever. And even as if things change, then update it, but keep them informed, because that's that frontline connection with employees, where if something is going to happen, or if somebody may not understand their responsibility in maintaining an inclusive work environment free of discrimination, that's typically where we see the issue happen. So you have newly promoted managers, even seasoned managers who've never gone through this type of training. That's important more than ever for them to have that exposure to that now.
Yep.
So just basically some tips to leave you on, and we'll certainly open this up for questions. So please feel free to chime in. And Lori, I haven't checked the chat. If you want to check the chat, see.
I haven't seen any
Okay.
chat comments yet. I've been looking.
Okay, be clear on your business needs. Remember, you're running this business. You have to make the decisions that are going to help your talent strategy so that you can deliver on your strategic objectives. Embedding some of these concepts into the way that you do business builds your business case for why you're doing what you're doing. It's important that you continue to track employee demographics using the voluntary disclosure form, because there's still, and Lori, correct me if I'm wrong, but there still is the Vietnam era Rehabilitation Act is still in effect.
So far.
You still may need to be able to certify, again, why you've made certain decisions. So if you have that data, then you will be able to defend decisions that you may have made with regards to recruitment, selection, hiring. Monitor and analyze non-discrimination policies for inclusion for all. Take a look at what you've done. We talked about going through your policies. Federal contractors, be prepared to comply with with the need to certify non-discrimination. Again, that might happen when you're applying for grants. It might happen when you're applying for contracts. And then lastly, just train your managers on good inclusive leadership. What does that mean? Continue to do anti-harassment training. Be mindful of who's facilitating it. Just make sure you've got someone strong in there. Unconscious bias training. Remember, it's not just race, gender, sexual orientation. It's all of the different ways that potentially bias could enter in and create discriminatory practices if it's not checked. And that awareness training is a first step to helping people understand or be aware that perhaps some of the decisions they're making are not objective.
And look, when I do training, in fact, I'm going to adjust mine, but when I do training and I do talk about all of these differences, these different issues, I do talk about unconscious bias. And one of the studies that I found most fascinating that I use all the time is the one where the orchestra was doing auditions and everybody comes across the stage and predominantly men are selected. And then they do it behind a curtain and then more women are selected. And then they say, like, you know what, we're going to do it barefoot, because they realize that people have a bias based on the click, click, click of high heels versus
That's amazing.
other shoes. And then with the last one being barefoot behind a curtain, even more women were selected. I still think that's a great example, but to the extent we're trying to be inclusive, we could add an example that shows where white men are being assumed, certain assumptions are made about them, instead of our examples always being about women, people of color. And look, some of you might be like, well, white men don't need that. They have a lot of privilege. I get that, but marginalizing any population tends to have a consequence. And I really do think that that's part of how we got here.
Yeah, and that's a good point to bring out when you're thinking about reviewing training content. Make sure that the examples or scenarios are really totally inclusive, to include white men, where in the past they may not have.
Right.
So that's just one of the things that you want to look for. So I'd like to just open it up to see if anybody has any questions. We know that this is a lot of information, and we also know that there are going to be changes to this. So the next time we meet, I believe, is in June. Lori,
That's right.
We'll be back again in June. But certainly if there are major changes, we will do something in the interim to update everyone. And I want to thank everybody for taking time out of your day to spend with us. We hope that you found some little golden nugget that will be helpful for you as you continue on this journey. We're there to be right alongside of you. I think we have a couple questions that may be coming in.
Here. Oh, web's breaking news. It looks like the president has um, just appointed a new general counsel for the NLRB, and it's somebody who's actually a good friend of mine. So, Crystal Carey. So if you see her name in the paper, she was with Morgan, very talented person. And that's great. All right, let's see. Any
I
comments?
don't see anything. No.
I just see some thank yous, and we appreciate you all
We
so
appreciate
much.
that too.
Yeah, thank you.
Lori, thank you again for being such a great partner, and we hope to see all of you back in June for our next morning blend.
Yeah,
Thanks,
thank you
everybody.
all. Have a great day.